All right. Welcome back. Let's do this one again, shall we? So, one of the problems, well, there are many benefits, I should say, to using StreamYard, even for recording videos, if you're not streaming. And there's one major flaw, and that is, of course, it's connected to the internet. But that's also a benefit for multiple reasons, but it's a major, major, major flaw because if it's not working, you're going to have terrible videos, terrible sound. And I apologize for putting one of those out the other day. Evidently, it was much worse than I realized. So it's gone. Let's just pretend it didn't happen and re-record. Do just blank slate, do it all over again. I had the Google Fiber people come in, and I have brand new equipment from them now. So, hey, that's good. It is a, apparently that he told me because I tried to. The new package came with a range extender, but we already had one, and I asked him to just set both of them up, and he said, "Well, that's not going to work because the old system is Wi-Fi 5. This is Wi-Fi 6, and it's fast. So as long as I don't have connection problems, it's fast. So hopefully that's that solved. And assuming it's solved, one of the reasons why I've resorted to reading legal filings. I mean, I found it enjoyable, so there's that. But one of the reasons I haven't been reacting to videos is because, well, between my old computer and shoddy Wi-Fi, and or the option between shoddy Wi-Fi or stringing Ethernet all the way across the house, it was easier to just do the court filings. But that being said, since I got my newer computer fixed and new Wi-Fi, I'm hoping to start doing videos again, reacting to videos, I should say. Think Law Talk with Mike. So, if there are court videos or sovereign citizen videos, not First Amendment auditor videos usually, because, they're just jerks. There's not much interesting about them. So, like I said, court videos, arrest videos, just you know the stuff. So, of course, there could be the occasional just reacting to funny videos. So send them to me, and let's start trying to do those, and even do live streams with them. Like I said, think Law Talk with Mike. It works, so why not copy? So with that, let's jump straight into today's agenda. I'm gonna try to do it fast, and you know what that means for me. But since this is my second time going through it, I'll try to do it even faster. But first, as usual, please support Professor Scofield. She's got a GoFundMe up for legal fees. We take a lot of entertainment and a little education from this lawsuit. For her, it is a expensive headache. So if you're able to, please throw a few dollars her way. I will greatly appreciate it, and she will even more so. So please do that. And with that, let's jump to the docket. Even though there's tons to do in Vegas, we are in Massachusetts, perhaps for the last time, although I have a feeling that delete laws, because as he says, he doesn't stop, he's incapable of stopping. I have a feeling he will not stop. And my guess is he's going to file a motion to reconsider. He might appeal. He might just file this in a new court. And why would he refile? Well, it was dismissed. And so let's scroll down, and we need to. All right. So just as a reminder, one of the things we're going to have to look at today. So way back January 16th of this year, docket number 103, Delete Laws did his second motion for contempt of court by Kate, and then entirely too much litigation spent on that, and Judge Burroughs never responded until now. So continuing to scroll down, we had on July 11th, and in the time since I did the first video, the docket has been put in order because 135 here was between 131 and 132, but Clerk of Court Caitlin McManus likes things to be in order, so that some courts could learn from her. But so we had a flurry on Slurpee Day, 7-Eleven, and we had the denial of the second motion for contempt. We had a denial of Delete Law's motion for disclosure. That's when he asked Judge Burroughs for all kinds of ridiculous disclosures, and she said, no, the court doesn't answer questions. So, and then we had the defendant's motion to dismiss granted, and Google's motion to transfer denied as moot because, well, once it's dismissed, there's nothing to transfer. And finally, a rare win for Delete Laws, and the counterclaims brought by Josh and Kate were dismissed, although that was on jurisdiction because the main claims were dismissed. So it was basically Judge Burroughs declined to exercise supplemental jurisdiction to keep jurisdiction over those claims because they hadn't pled sufficiently to keep it for under diversity jurisdiction. But and then 135 is just the order entered by Caitlin McManus dismissing. So that's what we've got to get through today. But like I said, we should be able to get through relatively quickly because most of them are, I think the longest is either 7 or 8 pages. And hey, it's well written. I'm not going to say it's written by Judge Burroughs because, well, let's face it, it could be written by a law student, a clerk. But either way, it's not written by Delete Laws, so it is well written, and it's concise, and it is good. And you'll notice, so as you know, Delete Laws has said that the attorneys covering him are dunce caps and biased and wrong and just, yeah. You'll notice, though, that in Judge Burroughs' ruling, it says the same thing that I have said, the same thing that Merb has said, the same thing that the attorneys have said. So, in the legal world, when everyone else is singing off the same hymn sheet and they're in tune, sound like a choir, and you're off in the corner banging your bongos or playing your triangle out of time, you're probably the one that is wrong. If everyone else is saying the same thing, it's because they are using the same sources. It's because they're right. So you'll notice that a few of our favorite cases are going to make an appearance. But with that, let's jump first into the denial of the motion for contempt from way back in January. So, memorandum and order from Burroughs DJ, and that would be District Judge Burroughs. Before the court is plaintiff Jose Decastro's second motion for contempt, in which he asks that this court hold defendant Catherine Peter in contempt of court. For the reasons stated below, plaintiff's motion is denied. Background: Decastro and Peter both publish videos on YouTube. On September 2nd, 2022, Decastro filed suit against Peter and another defendant for defamation and intentional infliction of emotional distress, alleging that Peter made defamatory videos about him, including, for example, a video in which she claimed Decastro was arrested for manufacturing and with the intent to sell a date rape drug. See e.g. ECF number 1. Decastro amended his complaint on November 16th, 2022, dropping his claims for defamation and intentional infliction of emotional distress, and instead alleging that Peter and other defendants infringed his copyrights. In response, Peter filed a counterclaim for defamation, alleging that, for example, Decastro published a video in which he falsely stated that she pimped out her daughter. She sold her daughter for sex. Over the course of this litigation, the parties have repeatedly claimed mistreatment by one another. As examples, on October 20th, 2022, Peter filed a motion claiming that Decastro makes it his practice to harass, threaten, and taunt parties and counsel, and that he had approached Ms. Peter as she sat in the gallery of an unrelated court proceeding and said, "You have no idea what's coming for you. You have no idea. I am going to destroy you." Similarly, Decastro filed a response claiming that Peter harassed him by email multiple times, and that she facilitated, directed, and led individuals to stalk him online and then sent people to confront him, even though that was his friend, or at least former friend, Sovereign Soul Unchained Mind, who apparently sent Daniel Clement to harass him on Hollywood Boulevard. At least that's my understanding. I do not watch Sovereign Soul Unchained Mind, so this is secondhand information. You might say secondhand news, which is a great song by Fleetwood Mac off of their Rumors album. As a result of the parties' treatment of one another, on October 21st, 2022, the court ordered the parties not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other, or with any individual or entity that may have knowledge pertaining to this matter. The court then held a hearing on October 24th, 2022, at which it stated, "I asked the defendant's counsel for a moratorium on the parties speaking about one another online, and they pointed out to me that they have a First Amendment right to speech, and I have suggested to them that they go back to their clients and reconsider the idea of a moratorium. I can't order them to suspend their First Amendment rights unless they're willing to agree to that. Same way as I can't make you give up yours. But if you people are going to continue with these videos and this kind of thing, you're running the risk that you're crossing the line into defamation or harassment. Defamation has legal consequences, and harassment will be in violation of my court order, and I will impose sanction if that's what happened. We'll begin with monetary sanctions, and we'll take it from there. So that is forewarned. And if I remember right, it was delete laws. I mean, Kate also said, no, I've got the First Amendment. But delete laws was especially against this. I mean, even though no one agreed to it, he expected Kate to, magically be bound by a non-existent court order. He thought if Kate makes any video mentioning his name, that is contempt. Whereas delete laws can make as many videos as he wants, be as vile as possible, and that's fine. And in fact, we'll see, Judge Burroughs points out, hey, it's not contempt for Kate to address you when you are in her comments section, that you sought her out. But he, in the deleted video, I said, in addition to being Captain Conclusory, I'm also decreeing that he is Jose Maria Antoinette, because instead of, let them eat cake, he wants to have his cake and eat it too. He, just yesterday, I didn't watch the video, but he did a live stream yesterday that was titled, Let's Watch Videos. So if anyone uses his video, even fair use, it's copyright violation. But he's allowed to use other people's videos because he's Jose Maria Antoinette. So that same day, the court issued an order reminding the parties of their obligation to comply with the court's order on October 21st, 2022, which forbids all parties from engaging in threatening, harassing, illegal, or otherwise inappropriate behavior with respect to the other parties in this lawsuit. Approximately 2 weeks later, on November 2nd, 2022, the court again cautioned the parties not to harass, disparage, or otherwise act unkindly to each other or any potential witness in this matter. Notwithstanding these orders, on November 14th, 2022, Decastro brought a motion for contempt, alleging that Peter violated the court's October 21st, October 24th, and November 2nd, 2022 orders by publishing a video on her YouTube channel in which Peter speaks directly to him and harasses him. Because he was in the comment section. Aha, I've got you now. He sought her out. He took the affirmative action. She responded. How, if anyone were to be held in contempt, it would have been him. In her response, Peter sought sanctions and claimed that she was responding to Mr. Decastro's antagonistic attacks, and that Mr. Decastro has sought to harass and threaten witnesses and others. The court denied both requests, finding that both parties have repeatedly engaged in inappropriate behavior towards one another, and the court will not single out one party for punishment where both are at fault. On January 16th, 2023, Decastro brought the instant second motion for contempt, claiming that, among other things, Peter published a YouTube video committing trade disparagement, incorrectly calling Decastro a liar several times, and inviting her followers to leave comments and fake stories on his unpublished website. Peter opposed the motion on February 1st, 2023. And that's the one where Kate did a live stream dissecting the endtorturecuffs.com website, which Delete Laws claimed was under development, and even though it wasn't, password protected or anything, so anyone could go to it. Anyone could leave a comment on it because it was there. It was open. It was available. But her doing it, that was beyond the pale. How dare she go to a website that is not password protected and critique it? Analysis. A district court may issue a civil contempt order if the moving party establishes by clear and convincing evidence. And so, clear and convincing evidence. That is between preponderance and reasonable doubt. So, some civil infractions, so like traffic tickets and stuff, are clear and convincing. Lots of stuff in estate planning is clear and convincing, since, in estate planning, the best witness is dead. So they want a higher level of evidence. So basically, preponderance is 50% plus something. So any level above 50%, you've met the preponderance standard. The reasonable doubt standard, there's no set number for it. Some people say it's 90%, 95%. It's you can't have reasonable doubts. Unreasonable doubts, well, there's a reason they're called unreasonable. So, I can't say, well, sure, Lee Harvey Oswald is an assassin, but, Lur from the planet Omicron Persei 8 might have helped him out. Yes, I am a Futurama fan, and I went there. But, that's a doubt that a juror might have, but it's unreasonable. So clear and convincing is somewhere in between. So it might be 70, 75% surety. So if a party establishes by clear and convincing evidence that 1, the alleged contemner had notice of the order. 2, the order was clear and unambiguous. 3, the alleged contemner had the ability to comply with the order. And 4, the alleged contemner violated the order. And that's from Hawkins versus Department of Health and Human Services from the First Circuit in 2012. And that quote's from United States versus Sakochia from the First Circuit in 2005. See also Angiodynamics versus Biolytic from the Supreme Court in 2015. Peter concedes that she had notice of the court's orders and does not dispute that she had the ability to comply with them. Instead, Peter argues she did not violate the orders and that they are not clear and unambiguous. Peter also avers that Decastro does not allege with any amount of specificity how any of her actions amount to threatening, harassing, illegal, or otherwise inappropriate behavior that occurred when engaging with each other. The parties did not agree to a moratorium on speaking about one another on the internet, and the court declined to place a prior restraint on the parties' speech. Thus, the fact that Peter spoke about Decastro on the internet, even if it was in a disparaging manner, does not itself violate the court's order. The court also explained, however, that any videos made by the parties could not cross the line into defamation or harassment because defamation has legal consequences and harassment will be in violation of the court order. Though the court has repeatedly recommended that the parties refrain from hostile behavior, and does so again here, it finds that calling Decastro a liar and inviting others to comment on his publicly available website without more detail does not constitute harassment or defamation. Moreover, trade disparagement is neither harassment nor defamation. Thus, the court finds Peter did not violate the court's order, and Decastro's motion is denied with footnote 1. So ordered July 11th, 2023 by Allison D. Burroughs, U.S. District Judge. And footnote 1 says, because the court finds Peter did not violate the court's order, it need not address whether the court's orders were clear and unambiguous. Moving on, we have the dismissal, or no, sorry, I'm getting ahead of myself. This is the denial of Delete Law's motion for disclosure from Judge Burroughs, which was ridiculous. Before the court is plaintiff Jose Decastro's motion for 1. Disclosure of ex parte communications received by the court. 2. Disclosure of information regarding any personal bias or prejudice this court has against plaintiff. And 3. Answers from the court to 2 questions posed by plaintiff. Defendants did not file a response. For the reasons stated below, plaintiff's motion is denied. First, plaintiff asks for disclosure of any ex parte communications concerning this action. As support, plaintiff identifies the Code of Conduct for United States Judges Canon 3A4 from 2019, which provides, in relevant part, if a judge receives an unauthorized ex parte communication bearing on the substance of the matter, the judge should promptly notify the parties of the subject matter of the communication and allow the parties an opportunity to respond if requested. See Code of Conduct. Plaintiff also references the court's previous order in this action, providing that any communication received from a party to this litigation will be placed on the public record. And so you'll notice that the judge's canon, the Code of Conduct, says if they receive unauthorized ex parte communication, the judge should promptly notify the parties of the subject matter of the communication and allow the parties an opportunity to respond. Now, what do we call that? That's due process, because due process requires 2 things. First, notice, and second, an opportunity to respond. That's what that is. Notice right there, promptly notify the parties and allow them an opportunity to respond. So it always drives me nuts when sovereign citizens, you know, broken system, broken trust is one of the worst offenders at this. It's like, well, he's pulled over on the side of the road and he tells the cops, well, you haven't given me due process yet. And it's like, this is due process. This is your notice. You get to go to court. That's your opportunity to respond. This is due process. They seem to think that due process equals their process. The Constitution gives you due process. It doesn't give you your process. But let's take a look at the docket. Scroll all the way almost to the top. You'll notice docket number 6, letter/request for extension of time to file responsive pleading from Catherine Peter. That was sent as a letter to the court, to Judge Burroughs. Kate said, "Hey, I'm still looking for a lawyer. I need more time." Well, that was an ex parte communication. What did the court do? It put it on the docket. It gave Delete Laws notice that it happened. And of course, after Judge Burroughs had already entered an electronic order, Delete Laws made an application to the court for entry of default instead of, say, an opposition to the request for more time, although, of course, it had already been granted, so he could have got started on his nunc-pro-tunc nonsense early. But you'll notice, though, like I said, the court has put the ex parte, any ex parte communication from the parties on the docket. So the court has notified and will notify the parties of unauthorized ex parte communication bearing on the substance of a matter, and or will file on the docket any ex parte communication received from a party to this litigation. See ECF number 117 with footnote 1. To the extent plaintiff requests additional and broader disclosure, plaintiff's request is denied. And footnote 1 says, plaintiff references communications from Todd Lyon discussed at an October 18th, 2022 hearing. Mr. Lyon is not a party to the action, and any communications from him have no bearing on the issues before the court. So, second, plaintiff requests disclosure of information regarding any personal bias or prejudice this court has against plaintiff that may give rise to a reasonable question about the court's impartiality. There is no information to disclose in this regard, and plaintiff's request is therefore denied. Third, plaintiff requests that the court answer the following questions. 1. Is Judge Burroughs a member of any law enforcement police associations, including any and all contributions and awards? And 2, what does Judge Burroughs know about plaintiff in addition to the record for this action? So, for starters, Judge Burroughs doesn't have to answer those, but I will, kind of. To question 1, is she a member of any law enforcement police associations, and has she received any awards? It's irrelevant. And even if she has, the fact that Delete Laws is anti-police doesn't matter. If you could only have, like if you had the right to a judge with the same proclivities, the same opinions, the same actions as you, we wouldn't have a justice system in the United States. It would fall apart. It couldn't work. It would never work. But besides that, the judges can have their own biases. That sucks, but judges are human. They do their best. You don't have the right to a judge without biases. You have the right to a judge without undue biases, undue prejudice. So as long as the judge is able to put it to the side and rule based on the facts and law, you're not unduly prejudiced. So, sucks for you. And then as to the second question, what does Judge Burroughs know about the plaintiff? So I'm not a qualified mental health practitioner, so I can't diagnose someone as being a narcissist. I will say that from the colloquial definition of narcissist, Delete Laws is the supreme narcissist. He thinks that because he gets a couple thousand views on his YouTube videos, the entire world knows who he is. That's ridiculous. I mean, it's not even a rounding error of the United States population that knows who he is. He thinks that the entire Las Vegas Metropolitan Police Department is biased against him, and he thinks that there are memos that going around about him. It's like, no, you've been a minor annoyance to one or two precincts. They do not care. They have bigger fish to fry. They've got the Strip. They've got drunken, revelries on the Strip 24/7, and worse on Fremont Street. They don't care. They don't know who you are. They do not care. Judge Burroughs even less so. But let's say, he asked, has she watched my videos? You put every single one of your videos on the record. If she watched them all, that would have been a colossal waste of time. But if she watched them all, it's because you put them all in your pleadings. They were exhibits, a list of URLs, multiple lists of URLs. So if she's biased against you because of your videos, that's your fault. You did that. The court is in full compliance with all applicable ethical obligations and has no obligation to respond beyond that. The court nonetheless notes that it has no information to disclose in this regard that bears on the substance of this matter or the court's impartiality. Thus, plaintiff's third request is denied. Accordingly, plaintiff's motion is denied. So ordered July 11th by Allison D. Burroughs. Moving on, this is the dismissal of Delete Laws claims. Plaintiff Jose Maria Decastro filed suit against Joshua Abrams, Kate Peter, Google LLC, unknown John Doe defendants who publish on YouTube John Does, and unknown John Doe defendants working on behalf of Google John Does, claiming copyright infringement. And footnote 1, though plaintiff and defendants reference RICO violations of the Digital Millennium Copyright Act and plaintiff's prior but abandoned complaint, CECF numbers 1 and 67, the only count raised by defendant in the operative complaint, and thus the only claim before the court, is for copyright infringement. And that disappoints me a little bit from Judge Burroughs. Of course, Kate and Josh's attorneys, I don't know if it would have changed anything, but I wish they had, in their motions to dismiss, said, while the original complaints are not the operative complaints, we ask the court to dismiss the claims that were made in them with prejudice for failure to prosecute because, well, he failed to prosecute. And it's just an end round mockery of the prior denial of the motion to dismiss. And I mentioned when delete laws first entered for default against Kate in California that I have a feeling Kate has a strategy. I'm not going to comment if it's a good strategy or not, but I think she has a strategy, and I think she was waiting for this dismissal. And of course, that strategy would have been a better strategy if the court had dismissed that with prejudice, because, that then she'd just go to California and say, Judge Ford, these claims have been dismissed with prejudice. And so res judicata says, you've got to get rid of it too. But either way, before the court are Abrams and Peter's motions to dismiss and Google's motion to transfer, or in the alternative, to dismiss. For the following reasons, defendants' motions to dismiss are granted and Google's motion to transfer is denied as moot with leave to renew if necessary. And that would be, let's say, delete laws successfully does a motion to reconsider or successfully appeals, which he won't be successful, but let's just pretend that's a possibility. That's why leave to renew the motion to transfer exists. Background. The following relevant facts are taken primarily from the amended complaint and supplements. Footnote 2. Which the court assumes to be true when considering a motion to dismiss, citing Ruivo versus Wells Fargo Bank from the First Circuit in 2014. Let's take a look. Footnote 2. On November 16, 2022, plaintiff filed an amended complaint, which superseded the original complaint in its entirety. Plaintiff then filed 2 supplements to his amended complaint on December 2, 2022 and April 24, 2023. Plaintiff creates original video content and publishes it on YouTube to generate revenue. He claims that he is the owner of the valid copyright for the videos that he publishes. Defendants Peter, Abrams, and YouTube John Does also publish content to YouTube for monetary gain. The videos these defendants publish target the same YouTube content as plaintiff, and to save from having to create content themselves, these defendants have allegedly willfully stolen and copied plaintiff's content without his consent. As a result, these defendants profit from plaintiff's content simply by using it to save them time and money and the effort of creating their own content. In addition, Google and the Google John Does have caused plaintiff harm by interfering with his ability to exercise his copyright. Specifically, plaintiff has identified instances of alleged copyright infringement to Google and the Google John Does, but they have failed to take down the identified content. Google and the Google John Does have failed to take down the content because they determined that it is exempt from takedown based on a copyright fair use principles, notwithstanding that plaintiff told them that he had filed a court action identifying the allegedly infringing content. Plaintiff claims that their failure to address his complaints is in violation of the DMCA. Between November 16, 2022 and April 24, 2023, plaintiff filed the complaints seeking recovery for alleged copyright infringement. Defendants Abrams and Peter moved to dismiss, and Plaintiff responded to both motions in a combined opposition. Google separately moved to transfer or, in the alternative, to dismiss. Plaintiff responded. Google replied, and plaintiff filed a SIR reply. Because the same infringement claims apply to all parties, the court rules on all of the motions to dismiss in this order. Legal standard. You'll notice the legal standard the court is using is the legal standard that I have stated many times. It's not the legal standard that delete laws and it was discussing laws discussed that we told them at the time was very, very, very wrong. But, you know, what do I know? On a motion to dismiss for failure to state a claim pursuant to Federal Rule of Civil Procedure 12b-6, the court must accept as true all well-pled facts, analyze those facts in the light most favorable to the plaintiff, and draw all reasonable inferences from those facts in favor of the plaintiff. Citing U.S. ex rel. Hutchison versus Blackstone Medical, First Circuit, 2011. Additionally, a court may not look beyond the facts alleged in the complaint, documents incorporated by reference therein, and facts susceptible to judicial notice, citing MIT Federal Credit Union versus Cordisco, District of Massachusetts, which itself cites Haley versus City of Boston, First Circuit, 2011. And that's important. A court may not look beyond the facts alleged in the complaint, because delete laws didn't allege much in his complaints. Other than conclusory statements, not much was alleged. And especially the second supplemental complaint, which was, here's a list of my URLs for my videos. Here's a list of URLs of their videos. Copyright infringement. That's not even. Like, we'll get to our friends Iqbal and Twombly, which say, you know, the vague recitation of the elements of the cause of action, it isn't stating a claim. That second supplemental complaint didn't even recite the elements of the cause of action. That it really was nothing. But so Google entered its motion to dismiss and brought up, well, he hasn't registered any of his copyrights. He at the very least, he hasn't alleged registration of any of his copyrights, and that's required. And in his opposition to the motion to dismiss, he says, well, at least one of my videos is registered, and they could have found it, but the court can't look beyond the facts alleged in the complaint. He expects the defendants to go out and make his case for him. It was available for them to find, so they should have made the case for me. But that's not how it works, because that's ridiculous. Why would they make their case for you? But we'll get to that. A complaint must provide a short and plain statement of the claim showing that the pleader is entitled to relief. And that is Cardigan Mountain School versus New Hampshire Insurance Company from the First Circuit in 2015, quoting our old friend Rule 8A2 from the Federal Rules of Civil Procedure. And it must set forth factual allegations, either direct or inferential, respecting each material element necessary to sustain recovery under some actionable legal theory. That's from Gooley versus Mobil Oil Corporation, First Circuit, 1988. Although detailed factual allegations are not required, a complaint must set forth more than labels and conclusions. And that's from our friend Bell Atlantic versus Twombly from the Supreme Court in 2007. And threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. That's Ashcroft versus Iqbal. Rather, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And that's also from Iqbal. And basically, what do we remember from Iqbal? I covered it in pretty good detail a couple times, most recently in one of the Scofield filings. It was Ashley Guillard's opposition to the motion to dismiss her counterclaims. So in Iqbal, that's former Attorney General, U.S. Attorney General John Ashcroft, was sued by a gentleman, last name of Iqbal, can't remember the first name. Basically, he was arrested in the years immediately after 9/11, and he is, I think he's Pakistani, but he's of Middle Eastern descent. He's Muslim, and he said, sitting in jail, the Department of Justice has a systematic policy of discrimination against Muslims. Therefore, I am being discriminated against because I have been arrested. That was nothing but a conclusory statement. He didn't have any evidence of a policy. There very well may have been one, knowing a former Attorney General John Ashcroft. I mean, my uncle is from Iran. He, frankly, I don't think he's religious at all, but either way, he has a very Middle Eastern first and last name. And after 9/11, their home phone was definitely tapped. We're 100% convinced. That there was no evidence that he had done anything, that he was associated with anyone. He just was Middle Eastern. You'd hang up the house phone at the end of a call, you'd pick it back up, and someone would still be on the other line. Or you'd end a call and you'd hear a click that didn't belong there. So, like, I believe there were policies that were probably unconstitutional, surveillance that was probably unconstitutional, but Iqbal simply saying those policies exist, well, that was a conclusory statement, so that wasn't enough. And under the old standard, under Conley versus Gibson, which is from the 50s, that might have been enough. But under Twombly, it wasn't, although there was still some question. So even though the Supreme Court had decided Twombly only 2 years earlier, they took up Iqbal in 2009 and said, yeah, in addition to the standard of Twombly, we need to say this much more. But delete laws, being, Jose Maria Antoinette, thinks he has a different standard, as we will see in a minute. Analysis. To establish copyright infringement, a plaintiff must prove two elements. One, ownership of a valid copyright, and two, copying of constituent elements of the work that are original, citing Society of Holy Transfiguration Monastery, Inc. versus Gregory, First Circuit 2012, which itself quotes Situation Management Systems versus ASP Consulting, First Circuit 2009. First, to show ownership of a true copyright, a plaintiff must prove that the work as a whole is original and that the plaintiff complied with applicable statutory formalities, citing Society of Holy Transfiguration Monasteries, Inc., which itself quoted Lotus DevCorp versus Borland International, First Circuit 1995. With regard to statutory formalities, 17 U.S.C. Section 411A provides that a party bringing a federal copyright infringement suit must show that the party had either registered its copyright with the U.S. Copyright Office or that the U.S. Copyright Office had refused to register the copyright after the party had delivered the proper deposit, application, and fee to that office. Okay, and somehow I missed footnote 3. Well, it was right there at the end of, but it's what I was going to get to. Plaintiff cites to Federal Rule of Civil Procedure 8 and Feist Publications, Inc. versus Rural Telephone Service Co. from the Supreme Court in 1991 as supposedly supporting a lower pleading standard for copyright infringement claims. Neither does so. So basically, he's saying, well, Twombly and Iqbal don't apply because this case from 1991 somehow supersedes these cases from 2007 and 2009. So with in Westlaw and LexisNexis, the legal databases, if case law has been overturned, or even if there's negative treatment to a case, I think it used to be there was a physical book called Shepherds, and you'd shepherdize, you'd look in the Shepherd's book to see if it was still good case law. But I believe it's LexisNexis bought out Shepherds. It might be Westlaw, but both of them do the same thing. They both have it. It's just one is officially called shepherdizing, the other is not, but it's it among attorneys, it's the same as zippers and Velcro and Kleenex. It's like, yeah, those are trademarks for what Kleenex, I think, is Kimberly Clark, but everyone calls facial tissue Kleenex. So everyone calls the case citation reference in both shepherdizing. But either way, I bet you I don't have access to either of those very expensive legal databases, so I don't have access to shepherdizing. But I would bet you that it has at least the yellow flag indicating negative treatment, if not the red flag saying, yeah, Feist Publications was overturned by Twombly and Iqbal. Assuming that's the case, if I cited this saying, well, this is the legal standard I'm required to meet in a copyright infringement claim, I would be sanctioned. Any attorney would be sanctioned for this because it's that bad. But instead, since Delete Laws is a pro se moron, he gets footnote number 3. funny enough, Ashley Guillard makes the same argument in that case that, well, I I can make conclusory statements. That's fine. 17 U.S. Code Section 411A says no civil action for infringement of the copyright in any United States work shall be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. See Cortez Ramos versus Martin Morales, First Circuit 2020, which affirms the dismissal for failure to allege that registration had been obtained prior to suit. See also Foss versus Eastern States Exposition, First Circuit 2023, which says the copyright registration requirement set forth in Section 411A is a precondition to federal copyright infringement suits. How many times do delete laws say it doesn't matter? I don't have to register anything. And then after the motion to dismiss, he said, well, I've done it now, so that's good enough. It's a precondition to bringing suit. It's got to be brought first. Second, to show that a defendant copied constituent elements of the work that are original, a plaintiff must show that 1. The defendant actually copied the work as a factual matter, and 2. The defendant's copying of the copyrighted material was so extensive that it rendered the infringing and copyrighted works substantially similar. And that is citing Cortez Ramos, and Trusted Safe Pay versus Dynamic Diet from the District of Massachusetts in 2018. Defendants, in pertinent part, moved to dismiss because 1. Plaintiff has failed to show that he has met the copyright registration requirements to file suit. 2. Plaintiff has not identified any allegedly infringing materials from defendants. And 3. Plaintiff's claims are barred by the fair use doctrine. As to registration, plaintiff argues that he need only allege ownership of the copyrighted materials, which he has done, and that in any event, he hereby declares, in his opposition to the motion to dismiss, he hereby declares, in response to the motion, that he has successfully and completely registered at least one key video in his complaint, and that the registration can easily be found by searching the public catalog at libraryofcongress.gov. So even then, he just says, well, I did it and you could have found it. I haven't alleged it. I haven't told you which one it is, but you should have found it, so it can't be dismissed. With regard to infringement, plaintiff argues that the materials infringed by defendants can be further clarified through the discovery process, and that the facts that the defendants have not requested a more definite statement, but rather ask that this court decide fair use, makes it clear that the complaint was sufficient to give notice. But it's not. It's not, because if it were sufficient to give notice, the bare minimum would have been, this video of theirs infringes in my copyright in this video because. That's the bare minimum. Putting, this is a list of URLs of my videos. This is a list of URLs of their videos. Connect the dots. There's no notice in that. That's not sufficient notice. But even further, the defendants don't have to request a more definite statement. Their job isn't to say, well, you're almost there. Could you fix it? No, their job is to go to the court and say, he hasn't done it. Get rid of it. Yeet it. To quote Emily Baker, motion to yeet it. He hasn't done it. Get rid of it. But they're just supposed to say, well, why don't you amend it again and see if you get it this time? And it can be further clarified through the discovery process. Lawsuits are not fishing expeditions. That's against the rules. You have to lay out sufficient claims in the complaint to get to discovery, to survive the motion to dismiss. You don't get to say, well, there's not enough in my complaint to survive a motion to dismiss, but you should let me survive that motion anyway, because there's a chance that discovery will give me enough ammunition to amend. What the hell's the point of a 12b6 if that's the standard? If you have failed to state a claim, what's the point in a motion to dismiss for failure to state a claim if the court is able to just say, well, yeah, sure, there's no claim here, but you might find it in discovery. Go to the tackle shop and go fishing. What's the point in having rules if Delete Laws gets to just say, well, Your Honor, there's a possibility. I can further clarify it through discovery. It's ridiculous. The court agrees that plaintiff has failed to plead sufficient facts to support a finding that he has met the copyright registration requirement, which is a prerequisite to bringing suit. In the complaints, plaintiff pleads, without record support, that he is the owner of the valid copyright for the videos that he publishes. This is insufficient to support an inference that he has complied with the registration requirements of Section 411A. See Foss, which says, the copyright registration requirement set forth in Section 411A is a precondition to federal copyright infringement suits. See also Calden versus Arnold Worldwide, District of Massachusetts, 2012, which says, finding a plaintiff's statement that his work was fixed and copyrighted under the Copyright Act of 1976, USCA 203A, insufficient to plead a valid registration. Plaintiff's claim in his response to Google's motion that he has registered at least one key video in his complaint does not remedy the deficient pleading, because you've got to take the facts from the complaint. We saw that above. If a fact is not alleged in the complaint, it does not exist for the purposes of the motion to dismiss. Plaintiff must have 1. Obtained his registration prior to instituting this action, which it appears he did not. Footnote 4. The court takes judicial notice of plaintiff's February 2nd, 2023 registration of one video, which occurred both after plaintiff initiated this action on September 2nd, 2022, and after plaintiff first brought a copyright claim on November 16th, 2022. See Island Software and Computer Services versus Microsoft Corporation, Second Circuit, 2005. the district court was entitled to take judicial notice of defendants' federal copyright registrations as published in the Copyright Office's registry. So, plaintiff must have, 1, obtained registration prior, and 2, sufficiently alleged in the complaint that he did so, which he did not. See Cortez Ramos, affirming dismissal where plaintiff failed to allege that registration had been obtained prior to suit, despite finding there was no dispute that the Copyright Office registered plaintiff's work after he filed his complaint. See also the Cortez Ramos from the District of Puerto Rico in 2020, which was on remand from the First Circuit, denying motion to amend complaint because copyright was not registered prior to filing the original complaint. Thus, as plaintiff has failed to allege that he complied with the copyright registration requirements prior to filing suit, the court dismisses the complaints against all defendants. Because the court finds that the complaints should be dismissed for failure to comply with the applicable statutory formalities of Section 411, it need not decide whether plaintiff adequately pled a claim for copyright infringement. In any event, the court notes that plaintiff's complaints do little more than generally allege that defendants copied his videos. For example, plaintiff does not cite, identify, or describe a single instance of the alleged copying that would allow the court to infer that defendant's copying of the material was so extensive that it rendered the infringing and copyrighted works substantially similar. See Cortez Ramos. See also Trusted Safe Pay, which says, the mere allegation that a defendant copied the work of a plaintiff is insufficient on its own to establish a claim for copyright infringement. Citing Johnson, which says, copying does not invariably constitute copyright infringement. And then citing Feist. And then we have footnote 5. Similarly, the court does not have sufficient information to assess whether defendants' actions are protected by the fair use doctrine. Conclusion: accordingly, defendants' motions to dismiss are granted, and Google's motion to transfer at ECF number 121 is denied as moot with leave to renew if necessary. So ordered July 11th, 2023, signed Allison D. Burroughs, U.S. District Judge. Next, we have the rare win for delete laws. After plaintiff Jose Maria Decastro filed a complaint against Joshua Abrams and Kate Peter, asserting claims for defamation and intentional infliction of emotional distress, footnote 1, Abrams and Peter answered the complaint and filed counterclaims for defamation. Before the court are Decastro's motions to dismiss Abrams and Peter's counterclaims. For the reasons stated below, Decastro's motions to dismiss are granted. And footnote 1, the court has already dismissed plaintiff's operative complaint against all parties, ECF number 133, this being 134. A procedural history of plaintiff's claims is provided in that order. Because much of that history is not relevant for purposes of this order, the court does not repeat it here. Background. The following relevant facts are taken primarily from the counterclaim complaints, which the court assumes to be true when considering a motion to dismiss. Once again, citing Ruivo versus Wells Fargo Bank from the First Circuit in 2014. Because Abrams and Peter bring separate claims, the court describes the facts from each counterclaim complaint separately. Abrams' defamation claim. Abrams, who resides in Stoneham, Massachusetts, and Decastro, who resides in Santa Monica, California, both operate YouTube channels. Decastro has said on websites, chats, and webcasts, including on his YouTube channels, delete laws and the long since deleted, whether by him, which would have violated a court order to preserve evidence, or by Google for violations of terms of service. I don't know, but the long since deleted Chili's backup that, among other things, Abrams is a rapist and an attempted rapist, and that he went to prison for raping his girlfriend and beating up his father. Abrams claims that 1. These statements were all false. 2. Decastro made the statements with knowledge of their falsity or had reckless disregard for their truth or falsity. Of course, they're defamation per se, so, reckless disregard, either way. 3. Decastro made the statements with actual malice. And 4. The statements were designed to hold Abrams up to scorn, hatred, ridicule, or contempt in the minds of considerable and respectable segments of the community. And 5. Decastro intended to, and did, in fact, cause Abrams financial harm by reducing membership and viewership of Abrams' YouTube channels, which in turn reduced revenue earned from his videos. Abrams claims that the amount in controversy exceeds $75,000. Peter's defamation claim. Peter also runs a YouTube channel. Her channel has 26,500 subscribers, a lifetime view count of upwards of 2 million, and an average unique visitor count of approximately 40,000 per month. She has a modest but fiercely loyal fan base for the channel and maintains a reputation for meticulous research, accurate information, and accurate reporting. With respect to Decastro, Peter claims that Decastro is a public figure who has an IMDb page and has been featured in I assume that's supposed to say news articles, interviews, promotional videos, and national television programs. Peter published videos about Decastro that questioned his advertising of legal service. In response, Decastro spread defamatory lies and misinformation about Peter, including by falsely saying to nearly 50,000 YouTube subscribers, God, that's old, 50,000 alleged YouTube subscribers that Peter sold out her daughter for sex, pimped out her own kid, and the Division of Family Services took her children away, and that she was arrested for siphoning gas out of a car. Peter specifically claims that the statements regarding pimping out her daughter are false and denies that she was arrested for siphoning gas. Peter avers that Decastro's statements caused her damage. Footnote 2. Peter does not provide a jurisdictional statement in her complaint and does not explain where she resides, where Decastro resides, or whether the amount in controversy exceeds $75,000. And this is relevant because that would be required for diversity jurisdiction. When these claims were brought, they were brought under supplemental jurisdiction, which, good lawyering, you use what's called the belt and suspender approach. If a belt will hold up your pants sufficiently, a belt and suspenders will make sure that that plumber's crack is never shown. So if you are able to get it in under one theory, one jurisdiction law, but you're also able to get it in under another. So if you're able to bring it in under supplemental jurisdiction, which is what they pled it as, but it would also be diversity jurisdiction or federal question jurisdiction or whatever, Do both. Do both. Belt and suspenders. Because basically now the judges, because she has dismissed delete laws claims, she doesn't have original jurisdiction under that, which started as diversity jurisdiction for his claims, but then changed to federal question jurisdiction when he switched to copyright claims. But with jurisdiction from the original claims, original jurisdiction, supplemental jurisdiction is good enough. But the judge doesn't have to exercise it as original jurisdiction anymore, and she's declining to. And you'll notice, so every claim made by both Kate and Josh would qualify as defamation per se, meaning they don't have to prove monetary damage because it's defamation per se. But the problem is a minimum of $75,000 is the jurisdictional minimum requirement for diversity jurisdiction. So even though you don't have to prove damages for the claim itself to win, you've got to allege damages to keep it in federal court, unless it's supplemental jurisdiction. Procedural history. On September 2nd, 2022, Decastro filed suit against Abrams and Peter for defamation and intentional infliction of emotional distress, ECF number 1, and on November 7th, 2022, Abrams and Peter answered the complaint and filed counterclaims for defamation. Decastro moved to dismiss the counterclaims on December 8th, 2022, and for the Abrams counterclaims, and December 11th, 2022, for the Peter counterclaim. Decastro also filed supplemental authorities in support of his motion to dismiss Abrams' counterclaims on December 12th, 2022. Abrams opposed on December 21st, 2022, and Peter opposed on December 27th, 2022. Discussion. Decastro moves to dismiss both counterclaim complaints on 4 grounds. 1, lack of subject matter jurisdiction under Federal Rules of Civil Procedure 12b1. 2, lack of personal jurisdiction under Rule 12b2. You'll remember when he first entered this motion to dismiss, I said, well, the court has personal jurisdiction over you because you dragged Josh and Kate into court. You dragged them in. But in doing so, you gave the court personal jurisdiction over you for any and all other claims. Judge Burroughs is about to say that, but I said it. So, lack of personal jurisdiction under 12b2. 3, insufficient process under Rule 12b4, which is once again him playing games because, you know, even though if he thinks they had to go out, hire a process server or whatever. It's like, no, counterclaims, that they go on the answer and they just get filed on ECF, and you ask for ECF access. You play games with that, just like you are in Vegas, but by filing, you accept that, service of counterclaims is Rule 5, and you accept that through electronic means by being an ECF filer. But once again, Captain Conclusory being Jose Maria Antoinette. The rules are different. 4, failure to state a claim under Rule 12b-6. Because the court finds that Abrams and Peter have not sufficiently pled facts to support subject matter jurisdiction, the court only reaches the first issue. So it's dismissing under Rule 12b-1, lack of subject matter jurisdiction. And footnote 3 says, though the court only reaches subject matter jurisdiction, it notes that plaintiffs' arguments under Rule 12b-2 and 12b-4 are without merit. Regarding personal jurisdiction under Rule 12b-2, when a plaintiff brings suit in the federal district court for the District of Massachusetts, it submits itself to the jurisdiction of the court with respect to all issues embraced in the suit, including those pertaining to the counterclaim of the defendants, citing Lehman versus Krentler Arnold Hinged Last Co., Supreme Court, 1932. Regarding a failure to serve, Rule 5b-2e governs service of pleadings after the original complaint, and service is complete under the rule by sending it to a registered user by filing it with the court's electronic filing system. Abrams and Peter filed their counterclaims with the court's electronic filing system, ECF numbers 53 and 54. And Decastro received them as a registered user of the court's electronic filing system. See ECF number 44. How about that? He received ECF access before, because count it with me, 44 is before 53 and 54. Federal district courts have original diversity jurisdiction over all civil actions in which the parties are citizens of different states and the amount in controversy exceeds $75,000. So for Josh and Kate, the $75,000 is operative, but for Kate, the different states is also. But you may ask, well, hang on. It says you have original diversity jurisdiction over all civil actions in which the parties are citizens of different states. But Kate and Josh are both residents of Massachusetts. And last I checked, Massachusetts is a single state. That is correct. But basically, to do your diversity analysis, you've got to look at both sides of the V. So Decastro versus Abrams et al. So as long as no one on the left side is from the same state as anyone on the right side of the V, you've got diversity. So if there's multiple California residents suing as plaintiffs against multiple Massachusetts defendants, you've got diversity. If you've got, a California resident, a Utah resident, a Nevada resident, a Washington resident as plaintiffs versus two Massachusetts defendants, you've got diversity. But and even let's say it's, on the plaintiff side, you've got California, Utah, Nevada, Washington, and then on the defendant side, you've got, staying in New England, you've got Massachusetts, Maine, Rhode Island, Vermont, New Hampshire. You've still got complete diversity. But You add a Massachusetts to the plaintiff side, it's gone. Or let's look at Decastro versus Peter, the California state court claim. Unless they move to sever Daniel Clement, he is a resident of California. So he is on the defendant side of the V, and Delete Laws is on the plaintiff side of the V, also a resident of California. And I should say domicile, because that's actually what it is. The domicile versus residence is a little different, but for our purposes, it's the same. But there's not complete diversity. And since that would be, in order to get it removed to federal court, it would be under diversity jurisdiction. They can't, because that's state law claims, so it would have to be under diversity jurisdiction, no federal claims. So if they want to, they've got to sever Daniel Clement. But so let's see. And the legal citation, diversity jurisdiction, is 28 USC section 1332, and the court cited Esquine Mendoza versus Don King Productions, First Circuit 2011, and Garcia Perez versus Santaella. I'm sure I butchered that. First Circuit 2004, and Actus Fund LLC versus Drone Garter Inc., District of Massachusetts 2022. With respect to the amount in controversy, the sum claimed by the plaintiff controls if the claim is apparently made in good faith, and it must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal. And that's citing Anderson versus Vaguero, First Circuit 2023, quoting St. Paul Mercury Indemnity Co. versus Red Cab Co., Supreme Court, 1938. So what does that mean? So if you've got to be, let's scroll back up. It's got to appear to a legal certainty that they're actually claiming damages that would be less than $75,000. So let's say I survive the motion to dismiss and take it all the way to a jury trial, and the jury awards me $70,000. Does that mean that the defendant gets to then go and say, hey, the jury gave him less than $75,000, therefore diversity jurisdiction isn't met? No, because you've got to claim over 75,000 in good faith. The fact that you didn't win $75,000 doesn't matter. But so, and you've got to make it in good faith. So the judge is going to go over further steps, but while I'm thinking about it. So let's say I sue for a breach of contract, and I sent Delete Laws, well, and we had a contract. So I sent Delete Laws $100,000 for, 20,000 trifolds. Yes, I threw my money away, but let's just use that as our hypothetical. And realistically, Delete Laws doesn't send me anything. I say it's realistic because I understand he doesn't send t-shirts that are ordered, or at least he's failed to do so on multiple occasions. is my understanding. So I don't have to prove any more than that. I have alleged $100,000 in damages, and that is a sum certain. So if the court finds that the contract is breached and that I sent $100,000 and didn't receive anything, that's a sum certain that I am entitled to my $100,000 back. But let's say that I'm hit by a car and sue in federal court because, you know, that would be negligence and others, but those are state law tort claims. So I sue in federal court, and I haven't received a hospital bill yet, so that there isn't even that sum certain. But I know that I'm going to have bills. Well, if I'm not submitting receipts, it's not a sum certain yet. So I've got to be able to plausibly allege. Well, yeah, it's gonna be there because I've had these treatments which should cost this much. I'm going to have these other damages. Ongoing pain and suffering. I might have to show what pain and suffering is worth because that's harder. But let's say you're Josh Abrams. You're saying he caused me to lose revenue because of defamation. He caused my YouTube channel to lose revenue. And that revenue is at least $75,000. It's, well, how much revenue were you getting per video before? How much are you getting now? How many videos a week do you do? You've got to show how the math works, at least plausibly. So after his motion to dismiss, they probably should have done a reply saying, here's how we get to our damages. So normally, a plaintiff's general allegation that the dispute exceeds the jurisdictional minimum is sufficient to support jurisdiction. But when challenged, the plaintiff has the burden of alleging with sufficient particularity facts indicating that it is not a legal certainty that the claim involves less than the jurisdictional amount. Citing Anderson, which quotes Department of Recreation and Sports of Puerto Rico versus World Boxing Association, First Circuit, 1991. Wow, we're getting a lot of boxing citations. I mean, we've got World Boxing Association, we've got Don King Productions. It's just lots of boxing. I wonder if Delete Laws appreciates that. I'm sure he'd appreciate wrestling more, but for example, in Anderson, the plaintiff alleged that her claims exceeded the statutory amount in controversy requirement, and she demanded $7,186,785 in damages. Her complaint also claimed that she gave away free services on at least 30 occasions and asserted hundreds of canceled monthly memberships, the loss of over 8,000 clients and 2 employees, and lost profits. Defendant moved to dismiss under Rule 12b-1 based on plaintiff's failure to sufficiently establish that her claims met the amount in controversy requirement. In response, instead of proffering additional factual support, plaintiff simply relied on the face of her complaint. At 15 or footnote 4. As noted in Anderson, to fend off a jurisdictional challenge, a plaintiff may amend the complaint or submit additional documentation, such as affidavits, medical reports, or interrogatories. Neither Abrams nor Peter have done so here. I have a feeling they didn't particularly care about the counterclaims. It was more of an, you're suing me, so I'll sue you too. There. The First Circuit first found that because the defendant contested the sufficiency of the pleading, the burden shifted back to plaintiff to present with sufficient particularity facts that in some way support the contention that there is more than $75,000 at stake. Still quoting Anderson, which quotes Abdel Alim versus OPK Biotech, First Circuit 2012. The plaintiff did not meet the pleading requirement in part because she attached no monetary value to services given away or to monthly memberships, clients, and employees lost. Further, while plaintiff claimed lost profits, she proffered nothing as to the profits or overall value other than calling her company successful. Here, Decastro challenges whether the amounts claimed by Abrams and Peter exceed $75,000. As explained in Anderson, this shifts the burden to Abrams and Peter to show with sufficient particularity that it is not a legal certainty that the claim involves less than $75,000. Like the plaintiff in Anderson, they have failed to do so. Abrams pleads that the amount in controversy exceeds $75,000 because Decastro's actions have reduced the membership and viewership of Abrams' YouTube channels, which in turn have reduced the revenue earned from his videos. Abrams does not provide any specific calculation or estimate of monetary damages resulting from Decastro's conduct. For example, he provides no information about how many individuals view and or are members of his channel, how much revenue he gets from members and or viewers, or how many members and or viewers he lost because of Decastro's statements. And you'll recall, Delete Laws didn't either when he was relying on diversity jurisdiction on his original complaint. With respect to Peter, she does not even bother to state that the amount in controversy exceeds $75,000 and only generally alleges that Decastro's actions caused her damage. She does not explain how she has been damaged, and if she has been damaged monetarily, how and by how much. Thus, the court finds that neither Abrams nor Peter have established with sufficient particularity that it is not a legal certainty that the claim involves less than $75,000. See Anderson. Because Abrams and Peter have failed to plead sufficient facts to establish that the court has subject matter jurisdiction, footnote 5, the claims must be dismissed under Rule 12b-1, footnote 6. Let's take a look. The court also notes that Peter failed to plead or provide an indication that she and Decastro are from different states for purposes of establishing diversity jurisdiction. And footnote 6, because Decastro no longer brings claims for defamation and intentional infliction of emotional distress against Abrams and Peter, and because the court dismissed Decastro's copyright claims against all defendants, the court declines to exercise supplemental jurisdiction at this time, citing Eves versus LePage, First Circuit 2016, which says a district court may decline to exercise supplemental jurisdiction if the court has dismissed all claims over which it has original jurisdiction. Quoting 28 U.S.C. Section 1367 C3, vacated in part and reinstated in part by the First Circuit, reinstating opinion as to dismissal of state law claims. So, conclusion, accordingly, Decastro's motions to dismiss Abrams and Peter's counterclaims are granted. So ordered, July 11th, 2023 by Allison D. Burroughs, U.S. District Judge. And finally, we have the short and sweet order of dismissal. This is Caitlin McManus's Time to Shine. In accordance with the court's memoranda and orders dated July 11th, 2023, it is hereby ordered that the above entitled action be and hereby is dismissed by the court. Signed, Caitlin McManus, Deputy Clerk. So, barring any post-dismissal motions or appeals or whatever, we're done with Massachusetts for now. Of course, we might see this pop up again, so keep an eye out. So with that, a reminder, go support Dr. Scofield. The link will be in the description. Like I mentioned, I didn't mention it at the beginning of this video, but I did in the beginning of the last video that survived on. I have checked. I've emailed back and forth with Dr. Scofield. It is her. And any potential excess funds raised over and above the legal fees will go to a scholarship fund at the University of Idaho in the name of the 4 murdered students. So it's a doubly good cause. So also a reminder, it seems, at least, you know, my video, right? Basically, the video of me has been, frankly, scarily, like, it's been clearer than in the past. So I'm taking that as an indication of good internet. I've in the top left where it says live with a counter, I haven't received any bad internet signals there, and well, nothing's froze up on me at all. So I'm assuming that my internet has been good through this whole thing. So I'm going to take that as a good sign. And so send me court videos, send, you know, sovereign citizen videos, traffic stop videos. You know the drill. If Mike would react, if Artie would react, send it to me, and see if I react. And then finally, I am still doing shorts when you guys give me timestamps. So if there's an under 1 minute clip that you think I should do as a short, just give me the start and end timestamp and I'll do it. So with that, thank you. Once again, I apologize for putting out a shoddy video the other day. Hopefully this one is much better and makes up for it. And I will, well, do all the YouTubey things, like, share, subscribe, and I will see you very soon. Bye-bye.